Ladies and gentlemen, good evening. Just how many times have we heard that bail is the norm and jail is the exception in Indian jurisprudence? A million times, right? But reality is that when it comes to ordinary citizens like you and me, or activists, or opposition leaders, getting bail essentially is mission impossible. Of course, superstars are not part of this unfortunate reality. So if you're someone like Darshan, you can torture and murder a fan. You can try and pay your way out of the blame. You can boss your way around in jail and treat it like some sort of personal resort. And of course, you can get bail at will as well. As pictures of Darshan, ladies and gentlemen, out on bail, partying in Thailand, they are on your screens, emerged today. The Supreme Court totally lost its cool. On its target was the Karnataka High Court that had granted bail to Darshan and his girlfriend Pavitra Gowda on the 13th of December last year in the Renuka Swamy murder case. The Karnataka government had challenged it in the Supreme Court, and 7 months later, ladies and gentlemen, the Supreme Court is calling out the star treatment being given out to Darshan. To say that the Karnataka High Court was hauled over the coals is an understatement. Just take a look at what all the Supreme Court has said. The Supreme Court has called it a perverse exercise of judicial power. It said it was troubled with the approach of the High Court. It said, how could a High Court judge give bail on the ground that the reason of arrest was not specified in a murder case? Is murder not reason enough for an arrest? The top court said they could accept a session judge committing such a mistake, but not a High Court judge. At one point, the Supreme Court questioned if there was application of mind by the judge in granting bail, and also asked if this is how bail is given to all citizens. Ladies and gentlemen, essentially the Supreme Court possibly called out the special treatment being given to Darshan, a troubled star who stands accused of murder. Just by the way, ladies and gentlemen, this is the second time in a week that the High Court has been pulled up by the Supreme Court in the same case. The Supreme Court has said they will now decide if bail will stay or not for Darshan. And the Supreme Court is also saying it will not make the same mistakes as the High Court has done. Is Darshan's case just another reminder that the law is not the same for all of us, that the law is one for Darshan and different for the rest of us? My guest this evening, joining me for that debate, Bhaskar Rao is a former IPS officer, Commissioner of Police in Bangalore, joining us on the broadcast. Thank you, Mr. Rao. Good evening. Sanket Yanagi is an advocate joining us on the broadcast. Good evening. Mithun Vijay Kumar, a political analyst. Thank you very much for being part of the show. And Aditya Pratap Singh is a lawyer who is joining us on the broadcast as well. Bhaskar Rao, as a citizen, not just as a police officer, but as a citizen of Bangalore, do you feel the anger that the Supreme Court seems to have expressed against the Karnataka High Court today? Because essentially the sense is that if it is you and me, maybe not you because you're a former police officer, but if it is any common citizen, if it is me, if it is Mithun Kumar, it will be Tariq pe Tariq, Tariq pe Tariq, Tariq pe Tariq. We will not get bail. But for someone like a Darshan, but someone like a Ram Rahim, bail pe bail, very easy. You will get bail for anything. You will get bail to party in Thailand. You will get bail to cut your birthday cake with a sword outside.
The language of the Supreme Court of India is extremely pleasing to the common citizens of India because it has used such strong words against the High Court of Karnataka. Till now, we all always had highest respect. Of course, barring a few good judges who are balanced. This entire bail, interim bail and regular bail, it looked as if the entire High Court was sold out to Darshan. And the Supreme Court's argument and what the Honorable CJI and also what the double bench has mentioned is a great eye-opener. How the High Court judge has casually given away bail casts a huge question of the integrity of the High Court of Karnataka itself over there. And as you rightly mentioned, everybody has got tariq per tariq, and these people enjoy bail per bail. But it has definitely lowered the image of the High Court of Karnataka in the eyes of the citizens of Karnataka. We always used to hold it in such high respect that this is a temple of justice. But from the very beginning, we knew that this person, Darshan, who after having committed such a ghastly crime, thanks to the initiative, though I'm in BJP, the local government has ensured that the Congress government ensured that proper investigation is carried out and no compromise needs to be done, and it gave a free hand to Chandan, the investigator, to charge sheet this case. And when the bail was given here, it rightly approached the Supreme Court for the cancellation of the bail. I think justice has been done for the common innocent citizen of Karnataka, and Karnataka High Court judge, whoever it is, has literally been exposed, and he has brought down the image of the court in the eyes of the people.
I'm not sure justice has been done given the fact that the guy is accused of murder. He's out on bail. He was found to be smoking in jail, being treated like a VVIP. And on bail right now, he's in Thailand partying.
That's what I'm telling you. His bail, he's on bail. And whatever the Supreme Court has mentioned, that's what I'm saying, that it offers a ray of hope to us that at least there is someone much above the High Court who can ensure the rights of the common citizens.
Sanket Yanagi, the Supreme Court called this a perverse exercise of judicial power. Do you agree with it?
Yes, I agree with the observation of the Supreme Court. Wherever the High Court or the courts below, whose judgment or order are under scrutiny before the Supreme Court, Supreme Court will examine or judicially review the entire order and the application of a mind by the judges of the High Court in respect to the facts and circumstances of the case and the materials available on record and the seriousness of the allegations and the social impact as well. So it is not just that some argument has been made, some technical points have been raised, and that needs to be given a go-by to every principle which has to be considered at a particular point of time. Because the social impact which the case has, or the impression it is going to have in a common man, or the culprits who would also perpetuate the same or similar offences, they should be taught a lesson. The intention of the legislation is not just to curb the crime, but also to see that others be prevented from committing such offences. And the bail is a rule and jail is an exception though, but not in all the cases of this nature. Where there is a serious allegation pertaining to abduction, offense pertaining to commission of an offense pertaining to cold-blooded murder, destruction of the evidence of the witnesses or influencing the witnesses. This is not a casual case or the casual manner in which the exercise of the discretion be made in a casual way. So, in my personal opinion, there are three important aspects. One is lack of judicial application of mind by the High Court, which was considered by the Supreme Court. Number two, bail order is resembling almost like an order of acquittal. So that is also one of the points the Supreme Court has considered. Third one is mistakes in reasoning. The reasoning which was given by the High Court is not appropriate or not in tune with the evidence of the materials placed in the charge sheet. That is one of the points. And the likelihood of cancellation of bail could be on multiple reasons. Number one, it could be like interference with the process of trial because of the influence which he carried.
Okay.
And other witness intimidation or influencing the witnesses or obstruction to the justice. So, Sarah, there are certain medical records placed before the court, if you may remember, claiming that he requires immediate surgery. If I may say so, the point which was made out before the court or which was convinced before the court almost with certain documents that there is a medical emergency for which reason he needs to be granted a bail. There need to be an immediate surgery. But where is that surgery now?
Correct.
These are all the things
Thailand, that surgery
which
is
may
happening
lead
there.
to certain conclusion.
Sir, that surgery is happening in Thailand. It's on your screens. I don't know what kind of surgery is this. Aditya Pratap Singh, it is not just common citizens. It's the Supreme Court of India that is hauling the Karnataka High Court over the coals. The question is the bail was granted on the basis of what? On the basis of him requiring an urgent surgery. Where is that urgent surgery? What we are seeing right now is Mr. Darshan having a good time and partying in Thailand. Then one of the bail conditions was that he has to appear for every court hearing. He skips one saying he is unwell. And the same evening, he's seen at a film premiere. So this is special treatment, no?
Well, let us take a direct look at the Karnataka High Court order, which had granted bail to Darshan. Now, if you look at para 52 of the order, the court has based its order on certain principles. That the factors which the court considers while granting bail are seriousness and gravity of the crime, the specific role of the accused in the crime, the criminal antecedents of the accused, probability of the accused tampering with the evidence, tampering and with the evidence and influencing witnesses, what is the likelihood of him committing the crime, and his possibility of fleeing from justice and not being available for trial. Now, in this case, the Honorable High Court reasoned that the petitioners, that is the bail applicants, including Darshan, did not have serious criminal antecedents, like, as you would say, a prior criminal record. They are all persons with deep roots in society. And it also recognized the fact that the bail applicants, including Darshan, were in custody for the last 6 months, and the prosecution has cited 262 charge sheet witnesses and 587 documents in 13 volumes. So therefore, the court observed that the chances of the trial being completed in the near future are very remote. And thereafter, the court has also referred a catena of judicial precedents passed by the Honorable Supreme Court as well as other courts of India, and therefore the courts observed that it was a case was made out for grant of bail, and further the court also observed that it also raised one technical procedural ground that when the accused was arrested, non-furnishing of grounds of arrest was also cited as a ground,
which is something that the Supreme Court has questioned with triple exclamation marks, to say that we expect this sort of wording and this sort of logic from a sessions court judge, but definitely not a high court judge. When you're arresting someone and the person is accused of murder, you're telling us that grounds of arrest were not furnished? What sort of logic is that?
No, see, I understand one can understand the angst of the Honorable Supreme Court and the scathing observations. Of course, they warrant attention. But we must understand that when a learned High Court judge is hearing, because I am in the Bombay High Court and we can see that daily how many bail applications are listed before any judge of the Honorable High Court. In fact, let me tell you that, first on top they list the bail applications. First, they might list anticipatory bail, then bail. And last, then they tend to list applications for cancellation of bail and other things. And bail jurisprudence in this country is actually quite well defined. There are lots of judicial precedents. In fact, it is not uncommon for even murder accused also to get bail while the trial is pending. In fact, if you have seen the Indrani Mukherjee case also, after she spent around 7 years, like, of course, they also believe she is facing trial. And after 7 years behind bars, and since the trial is still going on, she was enlarged on bail. So I do feel that while the Supreme Court may have its reasons for making such scathing observations, one must also recognize and appreciate the fact that the order passed by the Karnataka High Court itself has cited several judicial precedents, laying down the basis for granting bail to the accused.
For 5 years, Umar Khalid doesn't get bail in this country, but a Darshan will get it within 5 months or 6 months. The point is, it's not just the Supreme Court that is seething. With this VVIP treatment being given out to Darshan, it is almost every citizen in the country who is watching. Mithun Vijay Kumar, can lawyers who are defending or trying to defend Mr. Darshan get away with the fact that in this country and in this country's jurisprudence, bail is the norm and jail is the exception? Look at the character you're dealing with. There is, one argument that has been made by Aditya Pratap is he had no criminal antecedents. Of course he did. He was accused of beating up his wife, abusing her.
He has had criminal antecedents.
Right. That has happened. He was accused of beating up a fellow actor.
It can always be a minor.
And merely antecedents won't, give you the right to say that somebody is not a criminal. let's not, go there. This is not the way we interpret the law.
Mr. Bhaskar, I'll come to you in a bit. Let Mithun make his point.
I want to look at this issue in a comparative manner, like the Supreme Court stated, and like you rightly mentioned in your introduction, ordinary citizens actually spend months, even years in custody without bail for far less serious offences. Many of them without any convictions also. So even in cases of alleged road accidents or verbal threats, we have seen bails being denied. And here we have a man who is accused of torture and murder, and he is released within weeks. So the question is, why is this differential treatment? That's what we are questioning. We don't want to get into the technicalities of law and everything. I'm asking you, why is this differential treatment? Is it because he's a celebrity? Is it because he has influence? And that's what is concerning people like you and me, ma'am. Because for us, it would be like you said, Tariq pe Tariq. But here's a man who's getting VIP treatment even in jail. Because if tomorrow the courts start treating influence as a shield, then we have lost the idea of equal justice. We need to understand that bail should be used, based on facts, not a person's fame, not his popularity cannot reduce the severity of his crime. And, I believe this bail was granted in just a few weeks while the investigation was still underway. And when the accused is someone with power, resources, and public reach, the court should be more cautious, is what I believe. But in this case, it's like one of the panelists, he said, there's a genuine concern about the witness influence or evidence tampering, pressure on the police machinery, and still it is dealt in a careless manner. This is actually concerning to every single citizen of this country because, let's not forget that Renuka Swamy was a young man who was tortured for 3 days. His body was dumped in a drain. His family deserves answers, not technicalities, not legal technicalities like one of the panelists is answering.
Aditya, would you want to just, respond to that argument before I go to Bhaskar Roy? The point is you can make all sorts of technicalities that you want to, but common citizens who haven't read the law like you have, what is the impression that goes out? Oh, Darshan is rich, he's famous, he has all the money in the world, he can buy the system. Just like Ram Rahim can buy the system because he has political influence. So we know just like Ram Rahim is let out of jail on bail before every election in Punjab and Haryana, Darshan can also get bail. Why not? Even he has power, even he has money, even he has fame, and he can go to Thailand and party.
No, first and foremost, I understand only certain cases get highlighted. But the fact of the matter is that the law of bail in this country has been refined and polished over several precedents. You have Gurbaksh Singh Sibbiya, so many cases you have where bail can be granted, where bail cannot be granted. And while the courts have held that no straitjacket formula can be applied, it has to be applied on case-to-case basis. Okay. The principles by and large are fairly constant. Now, to begin with, if we talk about his prior, as I said earlier, that the allegations made by his wife, etc., cannot be termed as major antecedents. Second, it's also a reality of this nation that criminal trials do take a lot of time. So the point is still, when could the court keep him behind bars?
But criminal trials take a lot of time for all citizens in this country. No, why is this largesse not extended to other citizens?
No, in fact, let me tell you that bail is quite common. In fact, I have myself seen in a Sessions case, I've seen a person literally been on bail for several years, come into a courtroom, and there the learned Sessions judge passes the sentence that life imprisonment. I've seen that person break down and the police takes him away. So granting of bail during criminal trials is a fairly common procedure. And secondly, the people always see, moment you see a start, immediately the allegations come, he's well connected and so on. Let me in fact say that in this case, while the prosecution was doing the investigation, there was no case that there was interference with the prosecution. There was no case that witnesses were being disappeared or documents were being tampered with. It was not the prosecution's case. So ultimately, because the purpose of bail is what? See, first and remember, this is a case where charge sheet is filed. The investigation was going on. He was in custody. Investigation is complete. Charge sheet is filed. So in such a case, then obviously, as we follow the criminal justice system where you have to prove the guilt of the accused beyond reasonable doubt. Because you cannot harbor a presumption. Because remember, in criminal major offenses, there is no presumption that the accused has committed the murder. This is not a 138 case where there's a presumption that, or that you have,
Bhaskar Rao,
committed
would you want to come in here? Would you want to come in here?
Madam, I am only appalled at the technicalities that are being mentioned. People in this country, ordinary people, need justice. And after having seen the gory way in which a young man was tortured to death, and after that a rich criminal makes so much of payment to others to be his alibi that you cover up and trying all this. Thanks to the steadfastness of the investigating authority and thanks to the steadfastness of the police administration and the government, that this case saw its logical end. And every day, even the media kept the pressure of how a person having lot of money power can do all these things, and the best of the best lawyers with all their technical jargon and technical minds, legal precedents, etc., have tried to defend him. But very happy, extremely happy, we are grateful to the Honorable Supreme Court of India that it has stood with the emotions, stood with the common man of this country and given justice. Why do we even castigate the taluka level courts or a district court for non-appreciation of evidence? Here, a judge of the High Court of Karnataka is not able to see where he should be given bail. Bail was sought for taking medical treatment. Medical treatment was never sought. Instead, the perpetrator is moving outside the country, enjoying his time in Thailand and making a mockery of the judicial system. And here we have the best brains talking about different judgments, etc., etc., to see that the accused is protected somehow or the other. At the bottom of it, we can only say that a hallowed institution like Karnataka High Court, for whom, because as you rightly mentioned, that a perverse discretion of bail has taken place, non-application of mind, and then a real acquittal of the order has already been signed by the judge. Means what more do you need? There is no judicial improvement. There is no judicial appreciation in addition or correction. It is only straightaway castigating the High Court for having made such a bail.
Mithun Vijay Kumar, I just want to put it on record here that Darshan is out in Thailand shooting for a film called Devil with the permission of the High Court. My point is the High Court and the High Court judge knew exactly what they were doing, right? This was, after all, Darshan they were dealing with, one of South India's biggest superstars. I wonder when judges, when judgments like this are written, when bail is given to a superstar accused of murder, what the social impact is. Do you know what has happened less than a couple of weeks ago again in Bangalore? This is a Darshan fan who decides, inspired by Darshan, to beat up and possibly try and murder someone who used to be seeing his girlfriend. And he's on record to say, I mean, there are videos that have surfaced that are telling us that they were inspired by the entire Darshan saga.
See, it's sending a very wrong message, and the people should have belief and faith in judiciary. But with statements like this or with bail orders like this, the trust in judiciary is getting lost somewhere. And I would like to tell the panelist who is defending Darshan that we must understand.
Very true.
Even after the investigation is complete and the charge sheet is filed, the court must still consider the gravity of the offense. I'm not a lawyer, but I'm still saying this is how the court follows the this is the procedure. Basically, they consider the gravity of the offense, the possibility of witness tampering, the nature of evidence, and the status of the co-accused. So these are things that courts generally take into consideration. But in this particular case, all that is not done. And there is a larger point that we must not ignore. Like ma'am said, this isn't just about one actor or the legal technicalities. It's about the message that it is sending across India. So if you are rich, famous, or politically connected, the system will somehow treat you differently. Is the larger message that is coming out. And that's very dangerous signal to send out in a democracy like ours. And we have seen cases where people with no influence get stuck in the system for years, just like the person defending Darshan rightly said. But the problem is that those people are from the marginalized communities and not people like Darshan. They don't get these, primetime debates or VIP lawyers defending them. They just wait, often forgotten. And here we have a man who is accused in a violent custodial style killing, and he's out on bail as if it's, just a routine FIR or something.
Well,
So that's the larger issue. And like the Supreme Court said, we have actually, sorry, I missed it.
No, go ahead. Complete your point because I'm out of time.
Yeah, so like the Supreme Court said, we would have actually understood if it's an error if it's a session court that has passed the order, we could have thought that it's an error. But when it's High Court with all its experience and responsibility, it's hard to believe that such a serious case is dealt casually. These incidents take faith of people in the system.
Okay, so here's where the case stands right now. The Supreme Court has not cancelled Darshan's bail as yet, but they are saying today, they have said today that they will not make the same mistake as the Karnataka High Court. Big embarrassing moment for the Karnataka High Court, time for them possibly to introspect when it comes to giving Darshan bail. But for the moment, we'll just have to wait and watch and see what the Supreme Court does in this case. We'll possibly have a chat once again then. Thank you very much, gentlemen, for joining us. Bhaskar Rao, Sanket Yanagi, Mithun Vijay Kumar and Aditya Pratap, thank you for joining us. Ladies and gentlemen, on that note, a break. There's more on the other side. Do stay with us.